doing. Try to talk to him. He's not talking to me. He starts walking away.
Welcome to U.S. Corrupt Cops, where we dive into the dark side of law enforcement and expose how corruption affects us all. Today's video uncovers how some cops' shady actions aren't just a threat to justice. They're costing entire cities millions of dollars. Stay tuned as we break it all down. If you like this video, press 1. On March 31st, 2018, Officer Romero from the Pueblo Police Department in Colorado approached Auditor Sean O'Connell while he was photographing the police department building from a public sidewalk.
How are you? Excuse me, sir. What are you doing? Hey. Hey.
Law enforcement officers are trained to handle 3 specific types of interactions with citizens: consensual encounters, investigatory detentions, and arrests. Consensual encounters do not require reasonable suspicion or probable cause, provided that a reasonable individual would feel free to leave or decline to engage with the officers involved. An investigatory detention, often referred to as a Terry stop, allows police to briefly detain someone for further investigation if there is reasonable suspicion that the person is involved in criminal activity. To arrest someone, an officer must have probable cause. In this scenario, the interaction between Officer Romero and Mr. O'Connell is classified as a consensual contact. Mr. O'Connell is not legally required to interact with the officer and is fully entitled to disregard him. Officer Romero is also within his authority by initiating a consensual contact with Mr. O'Connell.
Ask you a question. Who are you? Why are you taking pictures of the department? Sir.
However, the moment Officer Romero physically touched Mr. O'Connell, the encounter escalated into an unlawful investigatory detention. For an officer to perform an investigatory detention, there must be reasonable suspicion of criminal activity. The First Amendment protects citizens' rights to photograph nearly anything visible from public spaces, with only a few exceptions. The landmark 1967 Supreme Court case Katz v. United States introduced the reasonable expectation of privacy doctrine, granting individuals privacy rights in areas where privacy is reasonably expected, such as telephone booths or public restrooms. Photographing a local police station from a public sidewalk is entirely legal. Thus, Officer Romero lacked reasonable suspicion of any criminal activity.
Don't touch me.
Okay, I'm gonna put you in cuffs. Okay?
Fine.
You're gonna be put in cuffs. Okay, supervisor's on his way. Okay? I'm asking you questions here.
I can be arrested right now, being put in cuffs for taking pictures of the police department. Don't turn my phone off.
Okay, you are not in control here.
I am, actually. You work for me, I don't work for you.
46, I got one in custody over here. I need a supervisor.
You're gonna lose your job, buddy. It's illegal detainment. Can you please call a supervisor out here? This is illegal detainment under 16.3103.
Mr. O'Connell references Colorado Revised Statutes 16-3-103, which defines when an officer can stop a suspect. According to this statute, a peace officer may only stop someone if they suspect that person is committing, about to commit, or has committed a crime.
Okay. Hang on here.
You don't have permission to search me, I don't consent to any search procedures.
Okay, I'm waiting for a supervisor to come up here.
Okay, that's fine.
Okay.
What's your name and badge number?
Romero, 0702.
Okay, sounds
Okay.
good. Did you stop my video camera over there?
I'm not messing with you.
Can you tell this officer to take his hands off me and to uncuff me?
Oh, I don't want to tell him anything.
Okay.
You'll wait till a supervisor gets here, and you can talk to him from there, okay?
Alright, I'm done talking to you guys now.
Okay.
What's up?
He's taking a picture of the department, taking pictures of all our stuff here, so I don't know what he's doing. Try to talk to him. He's not talking to me. He starts walking away.
While taking photos in public is not against the law, it might raise suspicions. Officers can initiate consensual interactions with individuals photographing in public, but they cannot perform an investigatory detention without reasonable suspicion of a crime. Reasonable suspicion must be based on a set of objective facts that lead an officer to believe a crime has occurred or is imminent. Mr. O'Connell was on a public sidewalk during the daytime with no apparent signs of criminal activity.
Is that a reason to cuff me?
Yeah,
that
you're
reasonable
being
articulable
detained right
suspicion?
now. Yeah.
For what? For what crime?
Yeah. No, it's reasonable suspicion.
Of what crime?
Okay.
You have to have reasonable suspicion of a crime to detain somebody.
I am not going to speak to you.
That's
you can
fine.
speak to my supervisor when he gets here.
You have me in cuffs right now.
Okay, yeah. You're
So I'm
being
gonna
detained
talk-
at the moment. Yeah.
Because you're
Okay. What's that?
You're wearing you're a corporal? Okay. I don't want to answer your questions.
We're not asking you questions.
What? You didn't ask me any questions? You asked me what I was doing, what I was doing, what I was doing. I chose not to answer you, which I have a right to do. Do I not? I do. Thank you. I hope this doesn't take longer than 20 minutes. Then it turns into an arrest instead of taking. Hey guys, if I'm still live streaming, call the Pueblo Police Department. Let them know officers Romero and Waring, something like that, are both detaining me illegally outside the Pueblo Department. I don't know what street this is. Both your body cam. Is yours on?
It's always on. So I'm loading up. I'm loading up. This guy's on the corner. I thought he was taking a picture of the eagle on the department. He's like, okay, big deal. So I started putting myself in my patrol vehicle. So this walks past it. And I was like, oh, he's leaving. Can you answer?
Can't talk right now, I'm busy.
So he starts walking, so I back up. He's up next to this corner now taking pictures.
Officer Romero acknowledges that the sole reason he stopped Mr. O'Connell was because he was taking pictures in public. There was no circumstantial evidence presented to establish reasonable suspicion for the officer to carry out an investigatory detention.
Where he starts taking pictures. It looks like he's taking pictures of these signs. I don't know if he's taking pictures of these cars.
It's part of the organization of the First Amendment strike to.
Is it?
Yeah, so he's trying to see what he did.
Okay.
He has every right to do that.
Okay, and that's fine with that. I don't have an issue.
Cuff him.
I did nothing wrong. I was not breaking the law. This officer just illegally detained me under CRS 16-103.
I see your video, sir. Okay, that was fine.
Who am I?
First Amendment strike.
Okay.
I know exactly who you are.
Exactly.
Um,
So you know I'm not down here doing anything illegal.
I do.
I like to follow the license officer for
There's
deprivation of rights.
In summary, Officer Romero deserves an F for unlawfully detaining Mr. O'Connell, for not acknowledging him during a consensual encounter, and for not understanding the First Amendment protections related to public photography. Conversely, Mr. O'Connell earns an A+ for promptly requesting a supervisor, accurately citing the specific statute Officer Romero violated, and staying silent for most of his detention. I applaud Mr. O'Connell for asserting his rights and conducting an audit without provoking police, disrupting public discourse, or behaving inappropriately. Many auditors misuse their rights to challenge local police departments rather than using them to educate officers or citizens and prevent further misconduct. The responding supervisor also merits an A for informing Officer Romero about public photography, promptly recognizing Mr. O'Connell's rights, and guiding Mr. O'Connell on how to file a complaint against Officer Romero. This unlawful detention ultimately cost the city of Pueblo $41,000 after Mr. O'Connell sued the Pueblo Police Department for infringing upon his constitutionally protected rights. The lawsuit also led to significant policy changes within the Pueblo Police Department regarding public recording. This audit stands out as one of the most effectively executed in recent history, providing valuable educational insights for both officers and citizens. Next, on July 26, 2017, Detective Jeff Payne of the Salt Lake Police Department entered the University of Utah Hospital in Salt Lake City, Utah, attempting to obtain a blood sample from an unconscious and critically injured patient involved in a severe two-vehicle accident. The crash was caused by the other driver, who was fleeing the Utah Highway Patrol at the time and died in the collision. The Logan Police Department, managing the investigation, did not suspect the patient was intoxicated during the crash. Nonetheless, Detective Payne sought a blood sample to check for any chemical substances in the patient's system. Upon arriving at the hospital, Detective Payne spoke with Nurse Alex Wubbles about the blood sample, and she informed him that she needed to consult with hospital administrators and registrars to determine if a blood draw could be authorized. This interaction was recorded on Detective Payne's body camera.
I'm being threatened with to be arrested if I don't allow the officer to draw the blood.
Yes, please. So I'm going to arrest her. We have exigent circumstances for a blood draw on a patient that's upstairs. She is refusing, and my lieutenant says that if she doesn't,
department are you with?
Salt Lake City Police,
Salt Lake City.
which I'm sure you'll get to meet my lieutenant soon. And if I don't get to go get the blood, I'm taking her to jail. I'd rather not do that.
I'd rather you not do it either. We're all city protection.
Hi. Can you protect me? I've been threatened to be placed under arrest by this officer here. I'm trying to prohibit him from drawing blood on one of my patients who he does not have a warrant for.
If things still keep going the way they're going, I'm arresting her
We can't protect you.
for interfering with a criminal investigation.
That
If he's
to
conducting
have
an
a
investigation,
warrant.
it's obstructing justice.
Okay, I'm just being told what to do by my entire hospital.
And I'm being told what to do by my boss.
Okay, so
And I'm going to do what my boss says.
there's no reason that this has gotten as elevated as it has.
If he wants to arrest you, I'm going to stop.
He said if this guy's gonna arrest me, he's not gonna stop him.
Yeah. Let's go.
That's fine. I love the other right here.
Yeah. Let's not. We're not doing one thing or another until House Soup gets here.
Yeah, and I've got more of my guys coming up, so.
This officer's trying to arrest me. He's agreeing with this officer. He needs to have a warrant signed by a judge that says he can draw blood. And he doesn't have
And there's
that.
also the laws that talk about exigent circumstances and implied consent law, which does apply.
Okay, I can have you talk to our private field.
Okay, well,
But until he says yes,
okay, she's going to jail.
why?
Interfering with the criminal investigation. Per my watch commander, and I'm not going to argue.
Detective Payne threatened that if he was not allowed to draw blood from the unconscious patient, Ms. Wubbles would be arrested for interfering with a criminal investigation. However, it is unclear under which statute this arrest was threatened. According to Section 76-8-305 of the Utah Code, defining the offense of interference with a peace officer, a person is guilty of a Class B misdemeanor if the person knows or by the exercise of reasonable care should have known that a peace officer is seeking to effect a lawful arrest or detention of that person or another person and interferes with the arrest or detention. Since Detective Payne was not attempting to arrest or detain anyone, this statute was clearly not applicable to Ms. Wubbles' actions. Similarly, Section 76-8-306 of the Utah Code, which defines the crime of obstruction of justice and criminal investigations, does not contain any language relevant to Ms. Wubbles' conduct. We will address the legality of the attempted blood draw later in this episode, but assuming, for argument's sake, that Officer Payne was legally authorized to obtain a blood sample from the unconscious patient, there is a possible argument that denying the blood draw would violate Section 76-8-301 of the Utah Code, which defines the offense of interference with a public servant. The statute states that an individual is guilty of interference with a public servant if the individual uses force, violence, intimidation, or engages in any other unlawful act with a purpose to interfere with a public servant performing or purporting to perform an official function. However, even if the blood draw was legally permitted, it is doubtful that a court would find that Ms. Wubbles committed an unlawful act by refusing a blood draw that contravened hospital policies under the direction of hospital administration. Additionally, a prosecutor would likely struggle to prove that Ms. Wubbles refused the blood draw with the intent to interfere with Officer Payne's investigation, as she was merely following her job requirements. Therefore, even if Officer Payne had the constitutional authority to obtain a blood sample from the unconscious patient, it is improbable that Ms. Wubbles could be convicted under any interference or obstruction of justice statutes.
Okay, and it's coming from mine. But I either go away with blood and vials or body in tow. And that's my only choices.
What's up, Payne?
This young lady right here, right now, is not free to go about her business. Per watch command, if she does not allow me to go get a blood draw from a guy up in the burn unit, she's going to jail.
And I'm just trying to do what I've been told to do by the hospital.
Where's the disconnect?
Yes, that's the cell
What's the
phone.
problem?
They don't want to abide by the implied consent law or exigent circumstances. They want it to be a search warrant.
So where's the lieutenant? He's coming in.
I've talked to him on the phone. She's talked to him on the phone. He was the first one to tell her that if I don't get the blood, she's getting arrested.
I don't know why you have to be so awful and threatening. I'm not here to impede
I'm
you.
just stating what will happen.
We can both say that, sir. I'm just a nurse trying to protect the patients and do what my hospital has obligated me to do.
Believe it or not, I'm trying to protect him too.
I have 2 officers now. Another 2 officers are here threatening to arrest me.
They don't have PC.
Is this patient under arrest?
Nope.
He still says he's not under arrest. Do you have an electronic warrant?
No.
No. No to every single one. So this hold on, Red. So I printed this off. This is what I was told to print off. I have this. It says obtaining blood samples for police enforcement from patients suspected to be under the influence. This is something that you guys agreed to with this hospital. The 3 things that allow us to do that are if you have an electronic warrant, patient consent, or patient under arrest. And neither of those things, the patient can't consent. He told me repeatedly that he doesn't have a warrant, and the patient is not under arrest.
Okay, so I take it without those in place, I'm not going to get blood. Am I fair to surmise that?
Alex, you're not representing.
Yeah,
Okay.
I don't know. I have no idea why he's blaming me. I'm just representing.
Why are you blaming the messenger, sir?
She's the one that hit.
Ms. Wubbles reviews the hospital policy regarding police blood draws to Detective Payne and explains that since the patient is unconscious and not under arrest, officers cannot draw blood without a warrant. Earlier in the interaction, Detective Payne argued that implied consent laws apply to the situation and allow him to obtain the blood draw under Utah's implied consent law, found in Section 41-6 A-520 of the Utah Code. A person operating a motor vehicle in this state is considered to have given consent to a chemical test or tests of the person's breath, blood, urine, or oral fluids for the purpose of determining whether the person was operating or in actual physical control of a motor vehicle while having a blood or breath alcohol content statutorily prohibited under the influence of alcohol, any drug or combination of alcohol and any drug, or having any measurable controlled substance or metabolite of a controlled substance in the person's body. However, the statute also requires that a test or tests authorized must be administered at the direction of a peace officer having grounds to believe that person to have been operating or in actual physical control of a motor vehicle while in violation of any provision. Therefore, Utah's implied consent law does not authorize Detective Payne to obtain a blood sample from the unconscious patient, as he had no grounds to believe that the patient was operating a motor vehicle while impaired. We will examine the constitutional issues involved in police-ordered blood draws shortly, but it is important to note that contrary to Detective Payne's claims, Utah's implied consent statute does not permit officers to test someone's blood simply because they chose to drive in the state. Even if such a law existed, it would clearly be unconstitutional.
Sir, you're making a huge mistake right now. Threatening to burn.
Okay. No, we're done. We're done. You're under arrest. We're done. Okay. She can sit in my car while we're coming.
This is unnecessary, man.
You're right.
This is my department, and this is completely unnecessary.
I'm leaving now. with her. Okay? Anybody who wants to prevent that, that's your option. He will be taking them.
Please, sir, you're hurting.
Then walk.
No, I have no reason to walk.
Have a seat.
What is going on?
Hi, sir.
Hi.
Would you like to speak to this young lady?
Well, I need to talk to you first, and I'll talk to her.
Okay.
So they're arresting her for us.
She's called people. They say no, she will not take me up there.
She absolutely will not. Thank you. I have our privacy officer on the phone. They're busy. Give me a second. Okay, let me chat with her for a minute.
Yeah. We're breaking the law. If we're doing wrong,
Call
okay?
Tom Miller. Somebody.
Listen to me. If we're doing wrong, there are civil remedies. What I'm telling you is, we are not making mistakes. Okay? I've done this for 22 plus years. I know what the law is when it comes to search and seizure. What you have done, because your bosses are telling you to, has been to prevent this officer who was called out to do a job to do his job. That's obstructing justice.
Commander Lieutenant James Tracy, Detective Payne's supervisor, arrives on the scene and informs Ms. Wobbles that he is knowledgeable about search and seizure laws and that she has obstructed justice by preventing Detective Payne from obtaining the blood sample. Generally, the Fourth Amendment protects citizens from unreasonable searches and seizures, and a warrantless search of a person is only deemed reasonable under the Fourth Amendment if it falls within a recognized exception to the warrant requirement, such as the exigent circumstances doctrine. This doctrine applies when an emergency compels law enforcement to act without a warrant. In the 2013 case, Missouri v. McNeely, the Supreme Court ruled that taking a blood draw, which involves a compelled physical intrusion beneath a person's skin and into their veins to obtain a blood sample for use as evidence in a criminal investigation, constitutes a search under the Fourth Amendment. The court stated that such an invasion of bodily integrity implicates an individual's most personal and deeply rooted expectations of privacy. The court also determined that the natural metabolization of alcohol in the bloodstream does not create a per se exigency that automatically justifies an exception to the Fourth Amendment's warrant requirement for non-consensual blood testing in all drunk driving cases, and that whether sufficient exigency exists must be determined on a case-by-case basis. Nonetheless, it is crucial to understand that the exigent circumstances doctrine only applies when an officer has probable cause to believe the individual was driving under the influence. Additionally, in the 2019 case Mitchell v. Wisconsin, decided several years after this incident, the Supreme Court held that when the driver's unconsciousness requires him to be taken to the hospital before police have a reasonable opportunity to administer a standard evidentiary breath test, officers may generally order a warrantless blood test to measure the driver's BAC without violating the Fourth Amendment. However, the court clearly limited this ruling to situations where police have probable cause to believe a person has committed a drunk driving offense. In this case, there was no evidence suggesting that the unconscious patient was intoxicated, let alone probable cause to justify a blood draw under the exigent circumstances doctrine. Consequently, the officers effectively arrested Ms. Wobbles for refusing to allow them to infringe upon her unconscious patient's Fourth Amendment rights.
Do you know if this person a resident? So we're trying to get blood from.
I have no idea. I don't even know who
Another
he is.
problem. Okay. So why are you involved in this?
Because
You don't have anything to do with it.
Because I'm the charge nurse in the unit that he was admitted. My job is to help understand what we're supposed to do
But
and how.
you're not trying to understand. You're trying to sell us proof. That's all you're doing. Because he's going to tell me what your policy is. I understand what your policy is. I'm trying to tell you what I need legally. Okay? And your policy right now is contravening what I need legally.
Ultimately, the officers detained Ms. Wobbles in the vehicle for approximately 20 minutes before releasing her without pressing any charges. In late 2017, Ms. Wobbles secured a $500,000 settlement with Salt Lake City and the University of Utah without initiating a lawsuit. She informed reporters that she would use part of the settlement to help individuals obtain body camera footage of incidents involving themselves at no cost. The Salt Lake Police Department conducted an internal investigation into both officers involved in this incident. During the investigation, Detective Payne asserted that he was merely following Lieutenant Tracy's orders to arrest Ms. Wobbles if she did not permit him to draw blood. Lieutenant Tracy, on the other hand, claimed that Detective Payne withheld crucial information from him about the situation, including the absence of probable cause for the blood draw. In October 2017, Detective Payne was fired for his role in Ms. Wobbles' detention. In a decision notice issued by Chief Mike Brown, the 17-page letter detailed several policy violations and stated, "Your conduct toward Ms. Wobbles was inappropriate, unreasonable, unwarranted, discourteous, disrespectful, and has brought significant disrepute on both you as a police officer and on the department as a whole." Detective Payne appealed his termination to the Salt Lake City Civil Service Commission, but the outcome of this appeal has not been made public. The department also chose to demote Lieutenant Tracy to a police officer 3 position, which is 2 ranks below his previous lieutenant rank. Chief Brown issued a decision notice to Lieutenant Tracy explaining his demotion, listing several policy violations and stating, "Your immediate and impulsive decision to order Detective Payne to arrest Ms. Wobbles without first taking the time to fully inform and assess yourself of all the relevant facts and circumstances has adversely affected public respect and confidence in the department and brought significant disrepute on both you as a lieutenant and superior officer and on the department as a whole. I was disappointed in the manner and tone with which you spoke to Ms. Wobbles in hospital administration. You did not exhibit the requisite courtesy and respect we expect from our watch commanders." Lieutenant Tracy appealed his demotion to the Salt Lake City Civil Service Commission, and in 2019, the commission upheld Chief Brown's decision. In 2019, Detective Payne filed a lawsuit against the department and the city, alleging breach of contract, breach of implied duty of good faith and fair dealing, wrongful termination, defamation, libel and/or slander, and false light publicity. Although Detective Payne's attorney initially expressed a desire to apologize, Detective Payne later informed reporters that he never intended to apologize because, "I don't think there's anything that I need to apologize for." Instead, as he stated in his lawsuit, he believed the department made him a pariah and fall guy, and that he took the blame for what was apparently an out-of-date policy handbook and wholesale failure to train officers on what the law was and how it would apply to the given situation. In January 2022, Detective Payne's lawsuit was dismissed at the request of both Detective Payne and the defendants, likely indicating a settlement agreement, although the details have not been made public. As a result of Ms. Wobbles' detention, the Utah State Legislature passed HB 43 in 2018, updating the state's implied consent law to more clearly define when police officers are authorized to take blood samples in potential DUI cases. However, it is important to note that HB 43 did not alter the substance of the law, and the attempted blood draw in this incident clearly violated Utah's implied consent law as it stood at the time. Overall, Detective Payne receives an F for persistently trying to coerce Ms. Wobbles into allowing him to obtain an unconstitutional blood sample, showing a complete misunderstanding of implied consent and exigent circumstances laws, and forcefully arresting Ms. Wobbles for merely performing her duties. Although Detective Payne claimed he was following orders, police officers are individually responsible for understanding and adhering to the law, and he cannot justify his lack of knowledge about the relevant statutes in the Constitution by blaming a superior officer. I support Chief Brown's decision in his notice, where he stated, "It appears to me that despite withholding all of the relevant information from Lieutenant Tracy, you quickly made the decision to regard his order as justification for performing a custodial arrest of Ms. Wobbles, who had already become the object of your irritation. The evidence strongly suggests that Detective Payne viewed Ms. Wobbles as being contemptuous towards the police and used Lieutenant Tracy's order as a pretext to punish her for her refusal. Detective Payne's continual refusal to take responsibility for his mistakes or apologize to Ms. Wobbles for his harsh and unconstitutional actions is inexcusable, and clearly shows that he lacks the professionalism and demeanor required for effective law enforcement. Lieutenant Tracy also deserves an F for ordering Detective Payne to arrest Ms. Wobbles for refusing an unconstitutional blood draw. berating Ms. Wobbles for telling Detective Payne no when she was within her rights to do so, and speaking to Ms. Wobbles in a rude and condescending manner despite his own lack of legal knowledge. Although Lieutenant Tracy claimed he was not fully informed and blamed Detective Payne for not telling him there was no probable cause for the blood draw, this assertion is questionable. He can clearly be heard on the body camera footage stating that the patient was the victim of the crash. Even if Lieutenant Tracy was not explicitly informed that there was no probable cause, the fact that the blood draw was being attempted on a crash victim should have raised concerns about the blood draw's constitutionality. A competent officer would have verified the situation's details instead of assuming the blood draw was lawful. Like Detective Payne, Lieutenant Tracy seemed frustrated that Ms. Wobbles dared to refuse a police officer even though she was simply setting boundaries to protect her patient's constitutional rights. This indicates that Lieutenant Tracy has an inflated sense of authority and lacks respect for citizens' rights. Additionally, his condescending tone towards Ms. Wobbles was particularly appalling, given how incorrect he was about the situation. In my view, Lieutenant Tracy should be thankful he was only demoted. Ms. Wobbles earns an A+ for maintaining a professional and respectful demeanor throughout most of the encounter, ensuring that the officers did not conduct an unconstitutional blood draw on an unconscious patient, and steadfastly upholding her professional and ethical duties to protect her patient's bodily integrity despite facing repeated arrest threats. Although she did lose her composure during her forceful arrest when speaking to Lieutenant Tracy after being handcuffed and placed in a police vehicle, her reaction appeared to stem from fear and outrage. This is a completely understandable response to such unacceptable behavior by a police officer. I commend Ms. Wobbles for her bravery and integrity in the face of police incompetence and her unwavering commitment to safeguarding her patient, even though she should never have been placed in that predicament. I hope others can take inspiration from her example on how to firmly and respectfully refuse unlawful police orders. Thanks for watching US Corrupt Cops. If you found this video eye-opening, don't forget to like, share, and subscribe to stay updated on stories of corruption that need to be told. See you in the next one.